Now, legal advice privilege is important to be aware of if you deal with HR consultants or other advisors who are not qualified lawyers. The reason for this is that legal advice privilege applies to communications by or to a qualified lawyer with whom a client has a professional relationship. And what it means is that any written communications, whether they're in hard copy or electronic form such as emails, are subject to protection and do not have to be disclosed to an inquiring employee or during the course of litigation. So an employee, for example, might issue a data subject access request, which means they're entitled to see all documentation, whether hard copy or email form, which contains information about them in terms of identifying them. Now, if that information is contained in hard copies or emails which are subject to legal advice privilege, then it doesn't have to be disclosed. So if you were dealing with an HR consultant who was not a qualified lawyer, and you, for example, sent an email that said you're considering dismissing a particular employee, but you're aware there isn't a fair way of doing it, that particular document would have to be disclosed and would be disadvantageous to you if you were trying to defend an employment tribunal case once it's disclosed in due course. If that email was sent to your qualified lawyer for whom you'd taken advice, then it would not have to be disclosed. Now compare this with litigation advice privilege. This is where litigation proceedings are contemplated or existing and you've been notified about them. In that case, communications between non-lawyers and the client are also subject to privilege. So for example, if you were being advised by an HR consultant who was a non-qualified lawyer on a document in connection with litigation, that document would not be disclosable because proceedings were either in being or contemplated.